I'm a little angry. Since the election, I've made the decision to become more politically active. I want to see a greater discussion of events and topics, but I also want to see an accounting for how people conduct themselves and for how particular issues are talked about. And this is best done in the video format so that you can hear my voice and you can see how and why I think the things I do. And you can also see how I go about making my arguments and arguing with people I have disagreements with. A family member, my mother, posted this on her Facebook wall. And this is fine. It's her wall. She can do whatever she wants with it. You can even have disagreements. You may not believe this, you may not like it. That's fine. A friend of hers started doing what I will charitably call shit posting on her wall. I reached out to them and engaged them in conversation. And we had a conversation over Google Meets, which I thought was relatively productive. A few days later, the 25th, he started shit posting on our wall again. And this really annoyed me, partially because it's rude, like it's not your wall, and the person isn't engaging with you. You need to, in Facebook, this can be complicated and you can overstep your bounds. I've done it myself. I did it earlier this week in a different setting. But what annoys me isn't the shit posting, it is the lack of recognition of the own person's hypocrisy and how they conduct themselves. So, the shit post in context is he may be right. We approached it, and he makes the typical comment that everyone is doing this. That Biden also is ignoring court orders. That both sides are causing an issue. This isn't a defense of what the Trump administration is doing or of how they conduct themselves. It's just an attack that both sides do it. I disagree, but also, Biden isn't president anymore. Now, my request was for him to engage with the argument. And his reply, why don't you do the same? Biden defied the Supremes on student loans. I write for people who read and share common knowledge of the day's events. Sorry I do not fit in your echo chamber. When I pull something from a pub, I include that. Those of us who read multiple hours a day, multiple days over years, find it impossible to cite every source. We come to assume a well-read audience. This is kind of offensive on a lot of levels, because he's assuming that I don't read. He's also assuming that I'm asking for citations. I'm just asking for an argument. Like any argument. Any. Notice that there isn't a single argument here. So, I have agreed that I will research and follow his argument and see where it leads. So again, his claim is that Biden defied a lawful court order and was still forgiving student loans. Let's see where that leads. From here on out, I'm simply going to record the entire thing. I am not going to make any cuts. I'm just going to Google up, I'm going to find some answers, and I'm going to try to do a full accounting. So, Biden defies court order student loans. Well, this is interesting. Does not bode well. But I want to keep an account that these aren't enough. And even if I read these, I wouldn't necessarily believe them. I'd want to know where it came from. But we're going to read the articles. Okay? So the first one, wake up. Oh, God, it's a voiceover. So crises. Oh, this is interesting. They included a graph. I think this is interesting, and it shows a big pop-up of interest in recent days. In a newsletter, it's going to be payment. Everyone hates those. I laid out my standard for when I use the label. If the executive branch ever tries to do something the judicial branch says it can't, and the executive branch does the same thing anyways, openly ignoring the courts and undermining the court of law. The piece was passed around a bit and sparked a healthy discussion in the comments section. I know they say never to venture into an online comment section, but I've always been proud that whoever these readers are tend to stay pretty civil down there, including when there are disagreements. Even when readers are taking issue with the things I've written, I generally find the arguments to be fair and well-reasoned. In this case, there were at least 3 arguments that different readers brought up, all in a thoughtful and good faith way, that I think are worth responding to. Each of them brought up examples that basically ask the same question. So wouldn't this be a constitutional crisis by your definition? Understand the difference with which this is being argued. If this had been put in this way in the comments section, I would not be angry. I happen not to think any of the examples qualify, but I've seen them floated in other corners of the internet as well. So I thought it might be helpful to walk through my reasoning in case you've seen them mentioned too, and we're looking for an explanation. Here goes. Did Biden spark a constitutional crisis by canceling student loan debt? And here they make the same citation. And here the counter argument is presented. This is the argument that Mr. Comment section on my mother's Facebook page is making. And here's the background here is that President Biden announced, and notice he makes a link. Man, citation, that's nice. But keep in mind that my only requirement was that an argument be made. Keep in mind, he still has, the comment section guy hasn't made an argument for why this is a problem. His opinion is just that there's constitutional crises everywhere. And I guess he thinks that my contention is just that I'm angry about only one constitutional crisis. If there was a constitutional crisis, or if there is, and President Biden did it, understand that I'm going to be angry. I don't want presidents defying the courts. And it's really annoying because he and I talked about this 2 days prior. So, Biden's stated justification for doing so was the Higher Education Relief Opportunities for Students Act of 2002. Okay? Boom. The Biden administration argued that the text was broad enough to allow a much larger cancellation than was originally the statute's intent. Its original intent was to benefit members of the military. In this case, the person arguing this was citing, and cites another of his own articles. Now, you have to be careful because maybe you don't want to keep using these same articles from the same source. This is dangerous. We should look at other sources and talk about where they're coming from. But to make a long story short, the Supreme Court did not agree, and they ruled in 6-3 in June 2023 that the cancellation went beyond the allowable waiving and modifying. Okay? And after the ruling, the Biden administration did not carry forward with the program, but they tried different ways to relieve student loan debt. So they're not doing the same thing, but they're trying to take the different actions. They're taking other approaches. The ruling was not that you cannot just remove student loan debt. It's that you can't do it in a certain way. There's a huge difference here. One that apparently is lost on our friend, according to this argument. One such effort aimed at expanding existing loan forgiveness programs for specific groups, such as people who went into public service or people who attended fraudulent schools. So let's take this argument at face value. If a person went to a fraudulent school, of which there were many from 2010 through 2016, let's go ahead and see if that's true. Fraudulent schools. Loan forgiveness. Under the law, you may be eligible for a borrower defense to repay payment discharge if you took out to attend a school that misled or engaged in other misconduct. This seems like a way to protect them. If you've been ripped off, it would be nice if you had somewhere to go, especially when schools, colleges cost thousands, tens of thousands of dollars to attend a 4-year university. And you do not know ahead of time if a school is fraudulent. You do not know if you've been ripped off until after you've bought the goods. This is the type of program which I would think anyone would be in favor of. A defense against fraud. Okay? For-profit college student. So, there were 2 other attempts. One, an income-driven repayment plan, and the other a program to offer relief to a targeted group of borrowers, were blocked by the courts. Wait. They were blocked by the courts. These are other attempts to do the same things, and they were blocked by the court. Notice how there's no, did he do a defiance, or did he abide by these court rulings? It sounds like he abided by later rulings. He tried different attempts. It would be almost like going to the courts to seek remedy and trying all your available options in the courts. That seems reasonable. Because the Supreme Court did not rule in Biden versus Nebraska that the Biden administration could not cancel student loan debt, it ruled that the Biden administration could not cancel student loan debt in that specific way under the authority of the HEROES Act. Let's see if this is true. Notice that this is the Supreme Court case reference in question. Something that people don't know, I think, is that you can just read these. So, Opinion of the court. The Higher Education Act of 1965 was enacted to increase educational opportunities and assist in making available the benefits of post secondary education to eligible students in institutions of higher education. To that end, Title IV of the Act restructured federal financial aid mechanisms and established three types of federal student loans. Direct loans are, as the name suggests, made directly to students and funded by the federal fisc. They constitute the bulk of the federal government's student lending efforts. The government also administers Perkins loans, government subsidized, low interest loans made by schools to students with significant financial need. While FFELs and Perkins loans are no longer issued, many remain outstanding. The terms of the federal loans are set by law, not the market. So they often come with benefits not offered by private lenders. Such benefits include deferment of any repayment until after graduation, loan qualification regardless of credit history, relatively low fixed interest rates, income sensitive repayment plans, and, for undergraduate students with financial need, government payment of interest while the borrower is in school. The Education Act specifies in detail the terms and conditions attached to federal loans. It also authorizes the Secretary to cancel or reduce loans, but only in certain limited circumstances and to a particular extent. Specifically, the Secretary can cancel a set amount of loans held by some public servants, including teachers, members of the armed forces, Peace Corps volunteers, and law enforcement officers and corrections officers. The Secretary can also forgive the loans of borrowers who have died or been permanently and totally disabled, such that they cannot engage in any substantial gainful activity. Notice, we're going to pause here. Notice how this is directly correlating to our article right here. So far, it seems to correlate to what's going on. There's direct citations. It would be nice to have a citation or even an argument on the other side of this for my nameless commenter. But again, I didn't require that. I just wanted an argument of some type, some claim, instead of like this nonsense, which even after we talk about is still pointless, because the point is whether we have a constitutional crisis going on right now, and if that's bad. Ugh. But to continue, because I said I would. The Secretary is directed to discharge. So here they name the type of loans that may be discharged. Shortly after the September 11th terrorist attacks, Congress became concerned that borrowers affected by the crisis, those who served in the military, would need additional assistance. And it enacted the Higher Education Relief Opportunities for Students Act of 2001. The act provided that the Secretary of Education, for a limited period of time, with specific waiver authority to respond to conditions in the national emergency caused by the September 11th attacks. By its terms, the Secretary may waive or modify any statutory or regulatory provision applicable to the student financial assistance programs under Title IV of the Education Act, as the Secretary deems necessary, in connection with a war or other military operation or national emergency. The Secretary may issue waivers or modifications only as may be necessary to ensure that the recipients of financial assistance under Title IV or affected individuals are not placed in a worse position financially in relation to that financial assistance because of their status as affected individuals. So, an affected individual is someone who resides in the area and that is declared a disaster area. So, here, this is actually interesting. It's saying that this only affects people who are being hurt by a national emergency. And one can kind of guess what the next arguments are going to be by the Supreme Court. I'm just taking a guess here, and we're going to read and verify. But it sounds like the Supreme Court is going to argue, like, hey, this doesn't qualify as an emergency. Okay. So, they also say people who suffer direct economic hardship as determined by the secretary. So we've got waivers, not a problem. So the secretary took more significant action in response to the COVID-19 pandemic. So here, this is actually interesting because they're not going to say that there wasn't an emergency. They're going to say that they did too much. So here Biden is claiming that I think what's going to happen is that Biden is claiming that the COVID-19 pandemic qualifies as an emergency and that he can take these actions. That seems to be what is being argued. And the Supreme Court, I assume, is going to disagree. On March 13th, 2020, the president declared the pandemic a national emergency. Okay, yeah, Biden would have been sworn in by then. 1 week later, wait. No. This is President Trump. I believe. Let's check. March 13th, 2020, president. I believe that's President Trump. Oh, President Trump declared an emergency. Okay, interesting. One week later, then Secretary of Education Betsy DeVos announced that she was suspending loan repayments and interest accrual for all federally held student loans. Okay. This seems reasonable. Like you would want to help out students. And this was a national emergency. Okay. And then they give an extension through the end of 2020. Before that extension expired, the president directed the secretary, in light of the national emergency, to effectuate appropriate waivers of and modifications to the Education Act to keep the suspensions in the effect through the end of the year. And so Betsy DeVos, doesn't matter, may further extend the suspensions, broaden the eligibility for federal financial assistance, and waive certain administration requirements. Over a year and a half passed with no further action beyond keeping repayment and interest suspensions in place. But in August 2022, a few weeks before President Biden stated that the pandemic is over, notice this is 2 years. So 2 years have passed, and President Biden is stating that the pandemic is over. And the Department of Education announced that it was once again issuing waivers and modifications. Okay, so this is actually interesting. So they're ending the emergency, and the court is saying you cannot forgive these debts using this power in this act. They haven't said that yet, but that's true. Oh, this is interesting. So during the first year of the pandemic, this would have been 2020. Yeah, this would have been 2020. So the department's Office of General Counsel said the secretary does not have the statutory authority to provide a blanket or mass cancellation, compromise, discharge, or forgiveness of student loan principal balances. That's that's interesting. Notice that this is during Trump's term. That doesn't have any bearing on it, but just notice that the this is the council. The council is saying this. Huh. Yeah. Yeah. It's during Trump's term this is thing. After a change in presidential administrations and shortly before adoption of the challenge policy, however, the council formally rescinded its earlier legal memorandum and issued a replacement reaching the opposite conclusion. So, this is just something which happens in politics, which is frustrating. We would like there to be settled law that continues between administrations so that we do not have a seesaw effect where someone comes in and just changes everything. We would like uniformity of law. And so it's frustrating when general counsels come in and change these effects. It's one of my complaints about the current administration. And I think for this court case, I probably agree with it. It's like you probably shouldn't, like, even though I want student loan forgiveness, it you probably shouldn't be able to use a law that is made for emergencies. You probably shouldn't use that for prolonged periods of time. It shouldn't extend beyond emergencies. Okay. So the new memorandum determined that the HEROES Act grants the Secretary authority that could be used to effectuate a program of targeted loan cancellation directed at addressing the financial harms of COVID-19 pandemic. So the argument here is really that you can forgive loans during the pandemic, but you can't use that same power once the pandemic has ended. That's the argument here. I think it's a little weird. Like it's very conservative in like a scary sense, not like conservative in the political party sense. But it's strange that like the harms of not having student loans forgiven or anything, or canceling student loan debt, that only happens during this area, but there can't be any student loan forgiveness under these same powers for extended effects. I don't know. Hard to say what they're reading in here, but it's, I don't know if I quite agree, but you can see the argument. I've given both sides of this, where on one hand you don't want these emergency powers to extend beyond the emergency. I think that's fair. On the other hand, it's weird that we can't address or redress damages done even though they might continue past. But maybe. Let's keep reading. 2 months later, he published the required notice of his waivers and modifications. So here they're listing the parts. I don't actually care like how much. We just care why they're denying it. So this, which just details how much is forgiven, is beyond us. Though, if you're interested, like, it looks like a good thing, which helps people. Like, these look like they could really help. Like 20,000, depending on what you're going to school for, like that's a decent amount. That can help you. So 6 states moved for a preliminary injunction, claiming that this is weird. I'd kind of be interested in why this is happening. Like, do the states, is the money going through the states, or is, like, I guess the opposition here is weird to me. Like, I actually think that's a kind of an interesting question beyond the scope of this one. But this is like, why would the states oppose forgiving like loan forgiveness? Like, how does the money play out here? That's actually really interesting. I might look that up later. Okay, so the district court held that none of the states had standing to challenge the suit. This is, I think this is interesting because again, what are the damages? That's really weird to me. Usually, when you sue, you have to have damages, or you have to be damaged in some way. Like you cannot, an entity cannot sue another entity unless you've been harmed, damaged, or affected in some way. Um, I cannot sue Jim for what he did to Bob. Like, unless Bob is some way related to me. Like, you can only sue for your own damages, is my understanding. The states appealed in the Eighth Circuit plenary injunction pending the thing, so they put it on appeal. This is interesting. Okay, so Missouri had standing, and it's through the higher. Huh. It's weird that only Missouri. Like this is kind of interesting. Because again, it's not clear to me what the damages would be. Um, and there's so few state. Like I yeah, it's interesting. So with the plan on pause, they asked to vacate and grant some Latin. Okay. Oh, ooh, and they're going to address the standing. Okay. So it looks like they're talking about one state has standing. So the plan harms Mola. I'm really going to have to look up what Mola is. That's really interesting. So, oh, they're going to talk about it. Love it. Isn't this nice when people cite things? Get to learn. Man, I wish people did that in the comments. Missouri created MOLA as a nonprofit government corporation to participate in the student loan market. The authority owns over 1 billion in Oh, okay. So the problem is that he's forgiving these loans, but if it's not paying out the money, it's just saying these are gone. Then MOLA, which owns all of this, Missouri could have real, like, severe deficits. Um, this is one of those weird things where I kind of wish like, oh yeah, if you like, yeah, this is actually kind of interesting. Like, you wouldn't want to put, yeah, like, there's no reason. Missouri could be harmed because they're servicing so much of these loans. And if these are just forgiven, then it actually hurts their revenue. Whoa! Ugh, that's rough. So the states can't do this. Ugh, yeah. So this is $44 million a year. So yeah, this covers, like, these are real damages. Interesting. And yeah, because MOLA is a public instrument of the state. Yeah. I'd be interested in seeing, like, if these public instruments, if this is actually true, or if it's more complicated than that. Is MOLA okay? So it's a non-profit government corporation. No, this seems to fit. Like, if all of this is true, but I'd kind of want to look up and see if it's more complicated than that. But yeah, this is interesting. Its board consists of 2 states and like. Okay, so they're just talking more about this. Arkansas, and they're talking more. Um, oh, and so here they're judging. So one of the things they're addressing here is why Mola, if Mola should be the one to sue instead of Missouri. If Mola should be the one to sue instead of Missouri. This is kind of interesting, but I would like I would hate maybe a lawyer could give me a better thing. I would hate that we'd spend more money getting the right people to sue. Like do we really have to change Mola, which is like owned by like but maybe it's more complicated. Yeah. Like this part of the argument isn't very interesting to me. But it seems like they conclude that Missouri has standing. Okay. So the secretary asserts that the HEROES Act grants him the authority to cancel 430 billion of student loan principal. It does not. We hold today that this act allows the secretary to waive or modify existing statutory or regulatory provisions applicable to financial assistance programs under the Education Act, not to rewrite that statute from the ground up. You could read this as a protection of the court's authority. Like you don't get to just rewrite, or no, this would actually, um, it's stopping the executive from rewriting existing laws, which I think is generally good. You shouldn't be able to just rewrite laws. That's something that Congress can do, or apparently the Supreme Court. The HEROES Act authorizes the Secretary to waive or modify any statutory or regulatory provision applicable to the student financial assistance programs under Title IV of the Education Act as the Secretary deems necessary in connection with a war or other military operation or national emergency. That power has limits. To begin with, the statutory permission to modify does not authorize basic and fundamental changes in the scheme designed by Congress. The Secretary's previous invocations of the HEROES Act illustrate this point. Prior to the COVID-19 pandemic, examples include reducing the tax forms. So they're changing. And they're complaining about new modifications. These aren't moderate or minor. I'd be inclined to agree. Like you're forgiving a bunch of things. Um, hmm. Yeah, like and here they're talking about the specific steps. So all in all, this seems like pretty on par with what I've read. Notice that the Biden, like, we're also not challenging the thing that the Biden, like, I don't think there's any follow up that Biden defied this order. It seems like the argument is being made that he defied, that, excuse me, he didn't defy these orders. He went and tried other things. Let's see what those other things are. Uh, I don't care about this. So again, let's look at two other attempts. So let's look at these other attempts. Um, one new income repayment plan. So, income repayment plan. Biden stopped. Oh, okay. Let's see this. Oh, it sounds like this is okay. Well, this is in New York too. So this is CNBC. Mhm. Student loan borrowers are who expected under the new savings valuable. So the U.S. Appeals Court blocked the program. As a result, millions of people will need to switch to a new repayment plan soon. Um, Borrowers who are in save will have to pay more on their federal loan, or ew. Oh, okay. So he rolls out this plan. It's wild. Whenever you ask, like, I'm angry because the language here is really loaded. You're trying to save people money, but I'm trying to imagine like who is being hurt, like who is being hurt, or is this just obstructionism? Like if you're trying to help people, like the job of government to make like to protect its citizens, to offer services to its citizens to some extent, you can argue to the extent, and you want to make sure that these other governing agencies, that is to say the states, aren't damaged. But I'm kind of interested in some of the arguments here. Maybe I'll read them later. So my guess, based on the previous argument, is you can do a same argument as these states. Like a good faith, a steelman argument would be that the states which own these federal repayment, they own these loans. If you forgive these loans, the state is out money. They're out massive amounts of money. Um, Unfortunately, I like one kind of doubts their goodwill. Um, because it reads kind of like obstructionism. It's like, how dare you accomplish something? We'll put a stop to that. But maybe like I'd have to look at how much money is at fault. Like we saw in the previous example, like 44 million a year for Missouri. What's the Missouri state budget? I'm curious. State budget. Ugh. Ugh. Give me numbers. Okay. Jeez, discretionary spending is so insane. So 44 million. Hmm. The reason why I'm looking this up, like why I'm curious, is like this is the entire this is the funding. So they've got funding in like the billions. If these were like small amounts, like 44 like million, like that's like the revenue seems really small. It seems like you could just forgive that. Um the other issue at play here is if people just have their debt forgiven, I'm not saying that the state doesn't lose money, but having that debt forgiven is probably somewhat cheaper if the people are still in the state because they have all of this money that they wouldn't have otherwise had. And I mean, presumably Missouri has other taxes, property taxes and stuff. It seems like some of this goes back to the state, but it gets a little funky because like you'd have to look at how much of that is it would actually go back to the state. If it's only 5%, then the loan forgiveness is basically nearly the full amount. It could be, we looked at the other number, 44 million a year that they just lose every year. Um if the state gets some amount more in taxes from getting those loans forgiven, because they spent on, I don't know, sales tax or whatever, they might recover somewhat more of that. I don't know. If I had to guess, like let's say you just gave somebody $20,000 and they or excuse me, they you forgave $20,000 and they immediately went out and bought something. It seems like 5% would be the amount that they'd get back. Um, yeah, and so then the state still suffers a pretty heavy loss. Hmm, interesting. Hmm. So, thing, looks like it this got canceled. Great. Moved in. I don't believe our friend is arguing that this wasn't stopped. And I don't think the GOP is arguing that either. Um, finally, targeted groups and the other to offer relief to a targeted group of borrowers. Okay. Anyway, so this is one source. If I was interested, I could look at other sources. It seems like there's a lot of other things. And these are from PBS, these are from wide-ranging news sources. And we can look at each of these and fact check these. I've gone through the Supreme Court oral arguments and talked about what's going on. It seems pretty clear to me at this point that this is not a constitutional crisis. He tried to do a thing, was blocked by the courts, and he tried other ways to do a thing. The court's mandate was not that you couldn't forgive student loans or that there aren't possible ways to forgive student loans. You're not allowed to forgive student loans in that way. And also, he's not trying to just blanket say we're forgiving student loans. There's a difference between what's going on now and what happened in the past Biden administration. Let's talk because I just happened to see. Ugh. I hate the title of this, Wake Up to Politics. So let's actually just pause here. And here's the argument that sparking a constitutional crisis by, oh my God. Not enforcing laws, not handing out all current congressional money. I think that's in general bad. It undermines our system of government. It is a constitutional crisis because if Congress passes laws or the judicial branch makes a ruling and the executive does not have to obey, whether by not handing out enough funds or by changing those statutes, that is a problem. One of the issues, and this would be my argue for the current situation, the current administration is making changes to existing laws and programs that are mandated by Congress. These aren't small changes. These are large and sweeping changes. And one of the issues is that Republicans don't want to fight about this. The legislature doesn't want to fight about this. They're happy to go along with it, even though it's done in an improper way. I would argue that it is illegal. If you're curious on why I think that, well, there's people we can do like USAID illegal. So we have unions and stuff. So there's this. I tend to like Legal Eagle. And he has descriptions for what's going on. But they did it anyway. I'll include this link below, even though it does not have the particular descriptions and stuff that I would like. Anyway, this is what's going on. I believe I've covered every topic. I guess I do want to talk briefly, like if you are going to. No. Anyway, I will put it into the nameless commenter's court on, please tell me, did I satisfy your curiosity on why Biden didn't cause a constitutional crisis and why shutting down U.S. aid is illegal? Keep in mind that you haven't made any arguments on your side or justifications. You've just said that this has happened before, and that's not true. Have a good day. At this point, I think I've given this claim and comment way more goodwill than it deserved. At this point, I've engaged this person 3 or 4 times, and they have not once put forth a positive argument about the Trump administration or what the Trump administration is currently doing. Each time, it is a whataboutism. It is what happened in the past. Ugh, liberals. There's never an engagement on the substance of what is going on. But something else which I think is important is to show just how easy it is to counteract these arguments. A Google search, and the first thing that popped up is the counter argument. And again, if that doesn't satisfy you, we can read the Supreme Court arguments. We can go through the arguments. I don't mind. But it is annoying, and it shows how bad faith, how little effort the opposition has put into this, that they do not bring up their own arguments. They do not deal with what Trump is doing. It's only about the other side. We should call this out for what it is. And people who do this should be rightfully lambasted as clowns.